Experts, attorney Byron Henry. Byron, good afternoon.
Good afternoon. Glad to be with you.
Now, 11 states yesterday filed a federal lawsuit against the Obama administration over the mandated transgender bathroom policy in public schools. What's the basis of this lawsuit from your understanding?
Well, from my understanding, it's got twofold basis. The first basis is that when an agency such as the Department of Education or Department of Justice changes one of its internal rules, a certain process has to be followed with notice and comment. So there's a procedural context to the whole idea, sort of like with the immigration orders that President Obama issued last year or 2 years ago with respect to just changing an internal rule that didn't go through the process. That's number one. But the other ground is a little bit different, and that is that it basically is a usurpation, sort of also like the immigration orders, and that is that Congress has to change the law. You can't just, quote, reinterpret the law by rewriting it to cover additional classifications without congressional action. And up to the past year or so, most people assumed that these different laws banning discrimination, such as the Civil Rights Act, Title IX, and others, required amendment by Congress in order to cover transgender students, gender identity, and sexual orientation, and so forth. So it's one procedural, and the other that he basically the agencies overstepped their constitutional authority and basically rewrote or reinterpreted the law in a way that's foreign to the law without Congress's blessing.
I would assume that this is a suit that's going to have to go all the way up to the Supreme Court. What is the process? What are the steps? What courts will hear this case first? Especially if we're going to be at an 8-justice Supreme Court, a lower court ruling is going to be critically important in this case.
First court that will hear it is a district court, the Northern District of Texas, Wichita Falls Division, and there's a single judge, District Judge Reed O'Connor, who was appointed by George W. Bush, who will be the first judge to hear the case. He is what most people would consider a conservative judge, a conservative appointee. And basically the states are going to have to convince him that these discrimination laws, after discovery and full litigation on the merits, do not encompass gender identity. And even if they do, the states or school districts are allowed to implement safety policies or accommodations. They don't just have to open up all of their facilities, sex-segregated facilities like bathrooms, locker rooms, and other places just wide open without a concern for any safety or privacy. So that's the first step. And of course, whatever happens there will be appealed to the Fifth Circuit that sits in New Orleans and covers Texas, Louisiana, and Mississippi. And that is also a conservative court. They just heard arguments a few days ago on the Texas voter ID law, but it's a conservative circuit. And then if it rules, however it rules, the party could take that case to the United States Supreme Court, which the whole process is probably 2+ years, probably closer to a 3-year process if you go through the whole litigation spectrum.
All right, so by that time, probably we'll have a full bench at the Supreme Court. But what happens in the interim during this 2 or 3 year process? Will the Obama executive order regarding the transgender restrooms remain in force?
Well, so far it's a guidance letter and not an executive order. And unless the Department of Justice or Department of Education takes specific action against a school district or a state or a city, so to speak, for violating its directive, and like funds are actually threatened, then this will just progress through the courts, and nothing will happen in the interim unless there's a move made by one of the other sides. And since there's no federal funds in jeopardy today, because those funds have already been allocated and whatnot by Congress, and the other thing that could happen is that there could be congressional action. The Congress could step in and pass a law or repeal the rule. And the last thing that should happen is, remember, this is an executive agency's determination of federal law, which the heads of those agencies and the agency's view on federal law changes with the administration. So a new president could bring a new directive or new guidance on this issue. A President Trump may have a completely different view of it. A President Clinton may have a different view of it. So this could actually sputter out with the change in administration before it even gets through the process.
Well, and with a President Trump, we don't exactly know what he might do because he's already flip-flopped on this particular issue 3 different times in the last week.
Yeah, we don't know whether he would actually direct his head of the department, Secretary of Education, or Attorney General to change the directive, modify it in some way, maybe allow for an accommodation, or whether or not, if you had a President Clinton, for instance, she may go further and not provide any exceptions and apply this directive to basically all sex-segregated facilities or accommodations throughout the country on all public property. So you don't know how it's going to go, but it's certain to change with the new president.
We're talking with constitutional attorney Byron Henry in Dallas. Byron, is this much ado over nothing? Is it a lot of legal wrangling over really a non-issue?
It's not really, and I'll tell you why. The problem with this issue is there are so many federal laws and regulations which use the term because of fill in the blank, sex, race, disability, age, all of these different non-discrimination rules and statutes all have a set meaning. And up until now, we always thought you could verify someone's race. You could verify their sex. You could verify their race, their age, for instance. All those were facts that could not be contested. And because this first directive applies to education and the Civil Rights Act, what you have now is the possibility that it could put in jeopardy a fact-based understanding of these different categories so that you could have racial identity, you could have disability identity, you could have age identity, meaning I identify as someone younger or someone older. And legally, there's no reason why it doesn't make sense common sense-wise, but legally, all of these possibilities flow from the idea that gender is not determinable, meaning you cannot determine it as a matter of fact in biology. So it does have ramifications going forward to a lot of federal rules, a lot of federal statutes, and a lot of facilities that are and issues that are based on discrimination based on sex, race, disability, and age, and so on.
I often identify myself as a 12-year-old. At other times, though, I often identify myself as like a 78-year-old.
Yeah, sometimes I feel like I'm in the upper age categories, but my wife always identifies me as much younger. So I don't know which is the better class to be in for legal protection, but that's the class I want to be in, the one with the best protection.
We will stay in touch and continue to follow the story. Byron K. Henry on Twitter, if you want to follow him in Dallas, our constitutional expert here. We'll actually get an update from House Congress.